Okay, so, and we also have, I gather we also have the attorneys in the Ashford case, Mr. St. Lawrence and Mr. Nevins, correct?
Yes. Yes, Your Honor.
Okay, so here's the protocol that will occur with regard to both cases. The attorney gets to argue for in the ballpark of 3 minutes without interruption. After that, I'll turn to the most senior justice, which is Justice Lang. She will ask questions, and then we will go by order of seniority. I will ask questions last. If any other justice has further questions, I will invite those questions after my own. You have 15 minutes or until the questioning ends, whichever is longer. If you have a cell phone, please silence it. If you are on a landline, or for that matter, a cell phone, and you're going to be doing it by speaker, please put it on mute if you're not doing it. And when you are speaking, please pick up the receiver and speak into it so that all can hear. And with that, I ask Clerk Keneally to call the case.
SJC-12877, Commonwealth v. Keyshaun Taylor.
Mr. Padani.
Thank you, Chief Justice Gantz, and may it please the Court. Instead of beginning where a double jeopardy analysis would typically begin by asking whether the defendant was previously placed in jeopardy in a prior proceeding, I'll begin by addressing the first reported question of law, because many, if not all, of the errors the defendant is claiming were made by the appeals court arguably flow from that conclusion on that first reported question. So turning to that, this court must find that General Laws Chapter 269, Section 10N is a freestanding crime for at least 3 reasons. Because first, it would be consistent with the interpretation of 2 statutes that are identical in both form and purpose, specifically Chapter 94C, Section 32J, commonly referred to as the school zone statute, and Chapter 90, Section 23, Paragraph 4, which criminalizes operating under the influence while having a license suspended or revoked for a previous operating under the influence, which for ease of reference I'll just refer to as OUI, while OAS for OUI. The clear legislative intent behind both of these statutes, as well as Section 10N, was to authorize cumulative punishment for the commission of a statutorily enumerated predicate offense when the commission of that offense is accompanied by a specific aggravating factor. Now, the second reason is because Section 10N possesses all of the essential characteristics of a freestanding crime. It has elements, which I'll note, one of which is knowledge, and I can think of no sentence enhancement statute that has a mens rea requirement. It also carries a wholly separate conviction and sentence, and as this court held almost a decade ago in Commonwealth versus Johnson, Section 10N has a lesser included offense of subsection H. The last reason is that the appeals court itself has already acknowledged that Section 10N is, quote, not merely a sentence enhancement, but a conviction that is wholly separate from conviction under General Laws Chapter 269, Section 10A. And that language is from footnote 5 of Commonwealth versus Jean-Baptiste. And I'll acknowledge that the language in footnote 5 is not essential to the holding in Commonwealth versus Jean-Baptiste. So it's obviously nothing more than dicta in a Rule 128 decision, but I would argue that neither is the language in Commonwealth versus Brown, where the appeals court said the opposite, that 10N is merely a sentence enhancement. Neither was it essential to the holding in that case. So this court would not need to disturb the holding in Brown in order to resolve that question in this case in the affirmative. And with that, I will accept questions from the court.
Okay, I'll hear from Justice Link.
Yes. What do you do with the fact that in 1992 we held that 94C32J creates and punishes a distinct offense which can be charged separately from the underlying offense which gives rise to it, but that in Commonwealth versus Lodeholt in 1999, that was 2010, we said in order properly to convict a defendant under 10N, the has first to be charged pursuant to 269, 10A, or 10C. So in other words, doesn't that undercut your notion that the independence of 10N is different than is not different than that of 94C32J?
Well, first, Justice Link, I would point out that while at first glance Lodeholt is directly on point with this case, it is factually dissimilar in that the situation in Lodeholt was not as it was described by the appeals court in Dancy, where there was an oversight by the Commonwealth in not charging Section 10A. There was no factual support for charging 10A in Lodeholt. That was a possession in a home case, and I think in that case the Commonwealth mistakenly thought that 10N could serve as an enhancement to 10H. But nonetheless, I would say that the interpretations given to 32J and 10N, I acknowledge that they have diverged and inexplicably, but the jury instructions to 32J are very informative because they do, in essence, encapsulate the way in which we punish and the way in which we require a conviction to be sustained under 10N. It requires violation, proof of a violation of a predicate offense. So I would say that they're not dissimilar.
Well, we said in Taylor that you can bring you can bring a 32J indictment against a defendant. But the school zone stuff, you can bring a school zone charge separate and apart from a underlying drug offense, right?
Yes.
But you can't do that with respect to 10N.
Well, I think in
Are you
theory,
saying one of us is wrong? One of the cases is wrong? You're saying that Lodeholt was incorrectly decided in that regard?
No, I don't believe that Lodeholt was incorrectly decided. I think that in Lodeholt, a conviction for 10N could not stand where there was no allegation that the defendant possessed a firearm outside the home, and essentially there was no factual support for charging 10A. So in that respect, Dancy mischaracterizes the posture of the case in Lodeholt because I believe in Dancy it says that it was failure to charge the 10A was an oversight, and I don't believe that that's accurate. Okay.
What about the notion of the Morey principles, the elements test with respect to each? Is there a greater and a lesser?
Yes, I think that that argument is essentially acknowledged in the footnote in Commonwealth versus Rivas, where the SJC acknowledged that under the elements-based test of Morey, that 10A is a lesser included of 10N. While that obviously is dicta, I would also say that the previous decisions that have analyzed the relationship between 10A and 10N have always looked at that relationship through the lens of a double jeopardy analysis of duplicative convictions. And there, we've never needed to apply Morey because the legislative intent to impose cumulative punishment for a single criminal offense is clear. Undoubtedly. It's unambiguous that the legislature intended for a consecutive sentence to be imposed there, so it obviated the need to apply Morey. But in this context, we are looking to determine whether a separate and distinct evil that double jeopardy is meant to guard against is at issue, and that is successive prosecutions. And since the legislative intent to authorize successive prosecutions for 10A and 10N is not clear, then we must apply the elements of Morey.
Mm-hmm. Okay, well, I'm going to leave it for Justice Gaziano to continue with this.
Justice Gaziano?
Oh, thank you. So your position is that it is a independent freestanding crime, correct?
Yes.
Okay. So suppose you're Judge Colvin, a very fine district court judge. You go forward with this, you allow the case to go forward, and the defendant's convicted of the 10N violation. Under the statute, it says that whoever violates 10A by means of a loaded firearm shall be further punished by 2.5 from and after expiration of the 10A sentence. How do you sentence someone to from and after if there is no 10A sentence?
Well, so I think the proper course of conduct that we should have taken would have been for the judge to allow an amendment as to form, which would have been permissible because, as
but this goes to the statutory interpretation of what the legislature intended, whether it would be an independent crime or not. And the problem you've got is the last part of the statute says you have to sentence from and after a 10A violation, which to me implies there is a 10A violation, and it's dependent upon a 10A prosecution, correct?
Yes.
So that means it's not freestanding.
Well, I think then the same could be true for 32J, because there we have acknowledged that it is an independent crime, while in the same breath saying it still nonetheless functions as a sentencing enhancement because an element of
that's in Taylor, right? The language of a freestanding crime in Taylor.
It was also said in I believe it was Commonwealth versus let me think here.
Because in Taylor, all Taylor says, is, in my memory, is that it can be separately charged or indicted, correct?
Yes.
So that means, to use a 10N situation, you could charge someone with a 10A violation, and then a week later say, well, you know what, they have a loaded firearm, and we really don't like this guy, so we're going to bring a separate prosecution for 10N. That's fine, right?
In a completely separate subsequent proceeding?
Well, I assume they'd be joined, or maybe they don't even have to be. But you would, one necessarily depends on the other, but you don't have to charge them at the same time. You could charge them a month later, a year later, right?
Yes.
Okay. Those are all the questions I have.
Justice Louis.
Yes, I was also looking at the further punishment language in 10N, and I will go on to another issue, having addressed that. What about the position that you took at trial? Is there any concern about your argument at trial and the argument you're making now on appeal?
I think that fortunately the judge in the trial made very clear what he was basing his decision on, and I think that the fact that he expressly said that, the Commonwealth's failure to charge what would be required in order to prove the violation of N, by saying that Lode, Holt, and Dancy, citing those two cases directly, that Lode, Holt, and Dancy required that there be a subsection A charge, gets over any concern that that the judge relied on the argument that 10A is not a lesser included of 10N, and that's, I think, further made clear by the fact that the issue of lesser included was never mentioned in Lode, Holt, or Dancy. So the fact that the judge at the end of the day relied on those two cases, I think, makes it so that the element of judicial estoppel that would need to be satisfied, specifically that the judge relied on that representation, I don't think that element is met.
Thank you. That's all I have.
Justice Budd.
I don't have any questions at this time.
Justice Seifer.
I don't have any questions either.
Justice Kafker.
The same.
All right, let me just make sure I understand your position after the questioning of Justice Gaziano. You agree that, I believe, that 10N is a separate and distinct crime, and that a conviction of it is a separate and distinct conviction, much like a school zone, correct?
Yes.
And that you agree, I think now, that it is contingent upon there being a separate conviction and punishment for 10A or 10C.
Well, so as you'll see in the record appendix, if we look at the trial transcript, when the judge hears me on the motion for required finding of not guilty, there's two sentences argued in support of that motion, and that was that as an essential element of N, a violation of A would need to be proved, and that since that subsection was not charged, they could not satisfy that essential element of N. So I would argue that the proof required for a conviction under N is, as the statute clearly says, a violation of subsection A.
Okay, so, but Justice Gaziano notes that subsection N says that any punishment must be essentially on and after the punishment for A. So how could it not? How could there be a 10N without there being a conviction of 10A? Can you just charge 10N alone?
I think that in theory, so for example, hypothetically, if we went to trial on a 10A and a 10N, and they came back guilty on the 10A and mistried on a 10N, then there's no question that one could stand trial for a 10N, and all the Commonwealth has to do in that proceeding is, provide a certified copy of the conviction on A, and then prove that it was in fact loaded, and now that there was knowledge. The same is true as far as the sentence goes for the school zone statute. That also calls for a from and after sentence, and that also cannot be continued without a finding or filed or suspended. So I think that they are extremely, if not totally identical in their form and purpose.
So let me, ask the question, can a school zone be charged alone without there being a prior conviction of one of the underlying crimes?
I don't believe so. And I believe that the case that I cited in my brief, Commonwealth versus Pena, the Rule 128 decision from the appeals court, I think was that conviction on a standalone 32J charge should not have been upheld. And that's, I think, consistent with the interpretation that we've given 10N.
But the fundamental mistake here was that the Commonwealth proceeded on 10N alone, which you say they can't do.
I think that resulted in the charging error, and the error specifically being that single count was duplicitous because it states two offenses within a single count. That charging error could have been remedied by simply splitting those into two counts, because the language is all there. Both statutes are cited, as well as all of their elements and the respective penalties for both statutes. So the defendant was on notice of the offenses for which he could be convicted, as well as the potential exposure as far as the sentence goes. I think that by any constitutional or statutory measure, the complaint was sufficient.
But ultimately, because that didn't happen and there was an acquittal to end, you're claiming double jeopardy, correct?
Yes.
I have no further questions. Any questions of any other justice?
Yes, Chief. Just one quick question. Isn't 32J doesn't say further punished, and 10N says further punished. Is there anything to be taken from that?
I don't think that there's a meaningful distinction that is intended to be drawn from that. I think that, all else being similar, that it would be difficult to put undue importance in that single word.
Okay, thank you.
Any further questions? All right. I will note, by the way, that the last sentence of 32J says that in accordance with Section 8A of Chapter 279, such sentence shall begin from and after the expiration of the sentence for violation of Section 32, 32A, 32B, blah, blah, blah. So there is a sentence which requires it to be from and after as part of 32J. And with that concludes Mr. Pedani, and we'll start with Mr. McGee.
Thank you, Chief Justice Gantz, and good morning, Your Honors. May it please the Court, Michael McGee for the Commonwealth, and with me is Assistant District Attorney Emil Atta. The Commonwealth should be permitted to proceed with its prosecution under General Laws Chapter 269, Section 10A for three reasons. Number one, the legislature expressly provided for punishment under both 10A and 10N, so 10A is not a lesser included offense of 10N. Which is a sentencing enhancement. And the same evidence test under Maury is not applicable. Number two, in allowing the defendant's motion for required finding, the judge did not reach the merits of the case on the first trial, so jeopardy did not attach. And number three, the defendant is stopped from arguing double jeopardy required dismissal of the second complaint and benefiting from his manipulation of the proceedings. With that, I welcome any questions.
Okay, Justice Link. Justice Link, you may need to unmute if you're speaking.
I certainly do need to unmute myself. That's right. Thank you. Commonwealth versus Rivas. How do you answer the question there posed about whether or not it is a duplicative of another charge?
The 10N is 10A and 10N are cumulative punishments that were expressly provided by the legislature. In Commonwealth versus Rivas at pages 184 and 185, it states that, citing Rodriguez, that the legislature, where like here, the legislature has expressly provided for crimes and punishments that implicate the same conduct, a defendant may be tried successively for multiple offenses based upon the same conduct without offending the prohibitions of double jeopardy. Okay.
So let me really understand your position here. Are you saying that 10N is or is not an independently chargeable crime?
It's not a standalone offense.
Can you charge it independently?
You could only, under the circumstances that Justice Gaziano was discussing, where a 10A is charged, and subsequently the Commonwealth could charge a 10N based upon the evidence.
But how about a 10N and then a 10A, which is your instance? Isn't that your situation, a 10A and then a 10N? I mean, I'm sorry, 10N and then a 10A?
Correct. Under the circumstances of this case, however, it was charged in error under 10A first. The judge didn't reach the merits of the case, and the second complaint was brought properly under 10A. So under these circumstances, the second complaint was appropriately charged.
Okay. Well, I don't have anything else.
Justice Gaziano.
Can you address the appeals court finding about jurisdictional voidability? My thought is that the district court certainly had jurisdiction over this crime as opposed to other felonies. So how is that applicable, and does it matter?
Because the trial court did have jurisdiction over Chapter 2, Section 10N, I would disagree with the appeals court and agree with Your Honor. The way I see this is that the judge simply did not reach the merits of the case, and that's why the second complaint is appropriate. But I disagree with the fidelity, and cases cited by the appeals court are in opposite, there are cases where there was the indictments failed to state a crime or a specific violation under a certain crime, that Cantor's case. But the idea here is that I'd agree with the defendant on this point, is that it wasn't void, it was voidable, and it would have been voided if it proceeded past the required finding stage.
No further questions. Thank you.
Justice Louis.
Yes, thank you. But is my memory correct, though, that the judge phrased his decision in the context of a required finding?
You're correct, Your Honor. The motion that was filed was a motion for a required finding. The motion that was argued was a motion for a required finding, and that is how the trial judge articulated his findings. But what I would suggest to the court is that in the substance of what was done was that it was a finding based upon the law, that you cannot have a 10N without a 10A or a 10C, and that was explicit in his findings, and how the judge articulated his findings, and he was right. Those findings were correct. However, that I would suggest to the court was not an acquittal. It was simply a finding based upon the law, and the Commonwealth should be permitted to proceed with a 10A charge.
Yeah, I think the trouble I'm having, and it is unusual because the prosecutor did try to amend here to be able to move appropriately, and the defendant objected. So it's an unusual procedural posture. But if there's a required finding granted, and if a violation of 10N requires that 10A be violated, and the ruling is the evidence is insufficient, and a required finding is granted, in this very unusual case, why doesn't jeopardy attach?
Starting with the amendment, the amendment here was also properly denied. The amendment was one of substance. This is one where the judge appropriately denied that. And moving on to the findings, there was a clear discussion, and it was only argued based upon Load, Holt, and Dancy that this was could not be charged. 10N could not be charged as a standalone offense, and those findings were clear. It wasn't a case of certain facts not being in evidence or something of that nature. This was essentially a non-event. Not essentially, it was a non-event, and the Commonwealth position is that double jeopardy did not attach because the defendant was not placed in jeopardy.
Thank you. That's all I have.
Justice Budd.
I have no questions.
Justice Seifer.
I have no questions.
Justice Kafker.
No questions.
I have no further questions. So, unless there's anything you wish to say for the balance of your time, which you do have some time, Mr. McGee, is there anything you wish to conclude with?
No, Chief Justice Gant. I thank you all for your time, and I just would conclude with the Commonwealth request to permit the Commonwealth to proceed on the complaint for Clause Chapter 269. And I thank you.
Okay, well, that concludes our hearing with regard to the case of Commonwealth versus